Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Over the course of the past several episodes of the Indie Zone here on YouTube as well as the podcast, I've been reporting about two sets of documents that popped up on the case management page, the case summary page, maintained by the clerk of court in Ada County, that tells us that items have been filed in the case, but the public, I wanted to, as I promised I would, go over the one set of documents, and this has to do with the defense suppression motion regarding IGG DNA evidence. It is one of 13 suppression motions that Mr. Kohberger filed back on the 14th of November 2024 that are pending hearing before Judge Hippler on January 3rd and, if necessary, per the court's order of October 9th, 2024. The hearings will then, if necessary, spill over until the 14th. The first item that I wanted to bring your attention to was the defendant's motion to unseal the IGG suppression briefing and hearing. This one, January 13th, 2025. We, until now, did not know if this was a defense or a state motion because the entry on the case summary page did not tell us. We now know that it is defendant's motion to unseal IGG suppression briefing and hearing. The second issue that was unclear is what did the term briefing mean, and I took an educated guess that it would mean all of the filings that were related to the motion to suppress this IGG DNA evidence. The defense opposition filing was filed on December 6th, 2024. That was also pursuant to Judge Stephen Hippler's order, because he set out in that October 9th order when motions to suppress, when their responses, and when their replies would be. And we see here that the reply to the objection to defendant's motion to suppress was filed on the 20th of December 2024. So it's motion application for a court order. Response and opposition is the second paper. The third is the reply, that is the initiating party's opportunity to come back and to convince the court that whatever the opponent stated in their response is incorrect, and therefore, Judge, you should enter this order suppressing this evidence. If we look at the defense motion to unseal IGG suppression briefing, it says here, comes now Brian C. Kohberger, by and through his attorneys of record, and hereby moves the honorable court for, he's looking for the entry of an order, to unseal the investigative genetic genealogy, also referred to as genetic information or IGG, suppression briefing, and related hearing. That is page 1. If we go on to page 2 of this filing, we now see that what the defense is doing is providing their version of a procedural history. So it says here that Mr. Kohberger then filed a second motion to compel IGG discovery on October 15th, 2023, and he gives the dates in footnotes here. Third and fourth motions to compel discovery were filed June 22nd, 2023, and then April 15th, 2024, respectively. The court's concerns were the privacy rights of the names of the individuals identified on Mr. Kohberger's family tree relative to this IGG genetic information. The court's concerns, again, were the privacy rights of the names of the people identified in Mr. Kohberger's family tree, that the issue of the motion to suppress never was heard. Judge Hippler went ahead and entered this order of October 9th. He put together a schedule when the motion, when the response, when the reply was due, and when the hearings would happen in a very organized manner. Mr. Kohberger requests that the briefing be unsealed and that the hearing take place in open court. And he gives case law. He goes on to page 3, that stating that in addition to Mr. Kohberger's right to a public trial, the public has a First Amendment right to know what is going on in the courts. Here, the way in which the IGG material was accessed and used is a matter warranting public disclosure and should not be shielded from the public's right to know. So what they have argued in the suppression motion is that Mr. Kohberger's DNA was illegally obtained. This was a violation of his Fourth Amendment privileges, and therefore any of the other materials that were found as a result of this illegal search and seizure of Mr. Kohberger's DNA, according to the defense, is a matter of deep concern and is a matter that properly calls for the entry of an order suppressing this evidence. So he's really pounding on the fact that the public should know about this thing. And then it continues on to the final page where the defense concludes by stating, Mr. Kohberger has a right to a public trial and the public has a right to know how genetic information was used in this case. Neither the state nor Mr. Kohberger will be prejudiced by unsealing the briefing and holding the IGG hearing in open court. The pleadings and hearing should be unsealed. There has not been any response that we know of, at least by looking at the case summary page by the defense. This document was just filed January 13th, 2025. On January 1st at 10 o'clock Mountain Time, the court will hold a closed, sealed hearing, so the public will have no access to this hearing. By remote video means to 1, hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of IGG DNA, and 2, consider what portions, if any, and under what circumstances should the various motions set to be heard on January 3rd and 24th be open to the public, either live or by video. So here now we have concrete ruling from Judge Stephen Hippler for the first time that it's not January 3rd, and if necessary, the 24th. It is January 3rd and the 24th. Now we go into the next portion of this court order. The clerk will provide a video link to the attorneys of record who request a link and to the Ada County Jail so that the defendant may appear by video. Court has ordered that the Ada County Sheriff's Department is ordered to provide a secure and private space for the defendant to appear by video for this hearing as well so that he can watch the proceedings. Dated this 15th day of January 2025. So at this point, ladies and gentlemen, it appears that what's going to happen is we will not receive a schedule for the hearings on the 3rd and the 24th of January relative to these critically important motions to suppress until after this hearing, 2 days earlier on the 1st, and then we can expect to see some sort of a schedule, hopefully from the court, that will tell us beginning at 9 o'clock, as he did with the DP motions hearing, what dates, what time each one of the motions to suppress will be entertained, how much time both parties will have, as he did with the prior order scheduling the multiple motions to strike the DP were entertained. So at this point, we remain on holding mode, if you will. We'll wait to see if the state of Idaho does file any sort of a response, whether in objection or in agreement with this motion, and if and when they do, we will, of course, report back to you. This will now conclude this episode of the Indie Zone. If you have any questions, comments, thoughts, please leave them. All are greatly appreciated. This is Kathy. Thank you so much for joining us here today.